Hello, and welcome to another edition of Coffee Talk with immigration attorney Brian D. Lerner. In this particular episode, I'd like to talk a bit about a couple issues of importance with asylum. So I've got lots of other videos on, how you apply for asylum, what the basis are, and of course I'll have more detailed ones and on different issues in the future. But this particular video, I'd like to talk about two things that could happen, two rulings that could be made in an asylum case which will affect the applicant or you very negatively, depending on which ruling and depending on what you do from it. So the two particular rulings will be, which I'll discuss in more detail, will be adverse credibility finding or a basically a false or frivolous application. Okay, those are the two rulings. Now, first, just a very brief overview of asylum, just so you know where we're coming from here. More or less, it's somebody who essentially flees to the United States because of persecution in their home country. Now, there's lots of different grounds that people can apply on. There's lots of different rules, but for all intents purposes, just keep that small definition in mind, and then that will allow me to continue with the explanation of what an adverse credibility finding is and what a finding of a frivolous application is and what that means. Okay? Now, an adverse credibility finding, for all intents and purposes, means the judge thinks you're lying, okay, thinks you're not being truthful. And there's all kinds of ways that the judge will arrive at that conclusion. There's all kinds of law on how the judge is to arrive at that conclusion. And, of course, the jurisdiction that you happen to be in will have cases that will go one way versus the other way. There will, in fact, be some cases that seem virtually the same but are ruled differently in the particular jurisdiction, which all the more means that it is very important that you properly get immigration counsel who knows asylum law to argue your case, okay, and to present it to the judge. Because you may have a real good asylum case, but the fact is, if it was not presented properly, or if you've incorrectly filled out an application on the initial phase of it, and then during the testimony you say something different, of course that does go towards your credibility. Meaning, for example, in the application you might say that you have been persecuted because of ABC, but then when you're giving your testimony, all of a sudden you might have 3 more accounts of what may have happened and when it happened. So, the question is, why didn't you put that in the application? Why leave that out, and why is it all of a sudden now in the testimony? And that's vice versa. Okay, so it goes both ways. But in any case, we'll get into more detail in a minute, but the adverse credibility finding, again, is bottom line, judge doesn't believe you. The judge doesn't believe what you're saying is really true. Okay? Now, an adverse credibility finding is not good. Obviously the asylum will be denied, but there's ways afterwards of trying to make motions to reopen, of trying to explain the adverse credibility, of trying to apply for other things that you might become eligible for. Okay, so again, while an adverse credibility finding is not good, it is not as bad as a finding of a frivolous application. Now, if the judge finds that there's a frivolous application that has been made, then assuming that all of the I's have been dotted and T's have been crossed, you or the applicant will never be able to apply for any immigration benefit for the rest of your life. Okay, so given that, it is quite clear that a frivolous application finding is much worse than an adverse credibility finding. Okay, so what is a frivolous application finding? What does that mean? Well, first you look at the word frivolous. Okay, frivolous basically means without any basis, that there's absolutely no truth in it, and essentially that you knowingly made a frivolous application. So the law is that if the attorney general, and by the attorney general that means the immigration judges or anyone underneath the attorney general, determines that the foreign national has knowingly made a frivolous application for asylum, and that foreign national has received the proper notice of what's going to happen if they file a frivolous application, then that foreign national is permanently ineligible for any benefit under the Immigration Nationality Act. Okay, so there's really three separate parts to a finding of a frivolous application. It's not just the filing of a frivolous application itself that makes someone under this provision. First, it has to be knowingly. So, for example, I've got a lot of people that come in, they don't speak a word of English, and they come to someone who claims to be an immigration lawyer, or, for people in the Spanish-speaking world, they come to a notario, but here in the U.S., a notario does not have the same meaning as in, for example, South America. So they think that a notario is a qualified attorney, when instead the notario is just taking their money. So what happens is the notario fills the whole thing out in English, total lies, everything in there is an absolute lie, but just says to the client, sign here, sign here, sign here, sign here, and the client thinks that they're going to be getting a work permit in 3 weeks and a green card in a month. Okay, I mean, whatever they were told, and they did not knowingly file that. Okay, yes, they signed it. Yes, it absolutely was frivolous, but they didn't knowingly file it. And so, in that particular example of what I'm giving, they will not be permanently barred from immigration benefits for the rest of their life. Now, the next element of it, of course, is that it has to be a frivolous application. So a frivolous application really means that there's just no basis for it. It's all lies. There's no basis for it. It is basically done with the intent to try to get some immigration benefit, but there's absolutely no legal argument that could be made that this person really qualifies for asylum. Okay, so that more or less is the frivolous application, and that next, that the foreign national, the person who's in proceedings, has received the proper notice of what will happen if they file a frivolous asylum application. So essentially what happens is, at the time that they're served with the notice to appear, and the judge gives them the advisals, usually at the first court hearing, will specifically say something to the effect, if you file a frivolous asylum application, you will be barred from immigration benefits for the rest of your life, to give them notice of what will happen, because it is a very serious matter. It's not a type of ruling that obviously you want. I mean, there's one thing getting a denial of some benefit that you're applying for, which frankly those happen a lot. You apply for an H-1B or a non-immigrant visa, you apply for cancellation of removal, you apply for adjustment of status, you apply for humanitarian reinstatement, you apply for a waiver. I mean, I could go on, and if it's denied, it's denied. And then you go and try to make a motion to reopen, you try to appeal. There's certain events that may happen in the future that allow you to ultimately benefit and apply for relief again. So when there is a potential ruling that bars you for the rest of your life from immigration benefits, then you have to have notice of it. You have to be 100% aware of what's going to happen if you get that ruling. So if you do get that ruling, let me just give you an example. Let's say, and I've had this happen, I've had clients come to me with this situation. 10, 15 years ago, or whatever it is, they get a ruling of a frivolous application, which, of course, I had nothing to do with. I had no knowledge. They walk in my door years and years after it happened. And let's say after they got that ruling, they fall madly in love with a U.S. citizen and they have 13 children, 2 grandchildren, and 1 great-grandchildren, okay? And they've got their jobs here. They're volunteers in the church. They give all kinds of benefits to everybody around them. Well, in that particular case, they come in and they say, okay, I'd like to apply for adjustment of status. I'd like to get my green card. Well, then I go back in their history. I find out that they have a ruling for a frivolous application, and sure enough, what happens is they are then prohibited from applying for adjustment of status or from obtaining any benefit at all. So in that case, I cannot file the adjustment for them. In fact, what I have to do is I have to go back and try to find if, in fact, number one, the ruling was correct, if they did file a frivolous application, what the history was, what the procedures were, what happened, and why did they end up with a ruling of a frivolous application. A lot of times, if they weren't represented and they got that ruling, it might have been wrong. They might have been the person that didn't understand a word of English but just signed it. They might have not understood what the judge was saying. The translator who translated the proceedings might have improperly translated. Have you ever? I don't know if you've ever been in immigration court, but every now and then you get the judge who will give a long list of what he or she is saying, and then the translator comes on and gives like one sentence, or the other way around. The judge will give like one sentence, and then all of a sudden the translator goes on and on. So the translator is not translating exactly what was said. So there's different things that we can look at, but the way to go about this for someone who already has such a ruling and now wants to get some immigration benefit is we have to go back to the immigration court and we have to do a motion to reopen based upon the fact that the ruling was improperly given. Now, that's the only way. There is no other way to get immigration benefits other than to show that that ruling was not correct and that it was given incorrectly and that, in fact, it should be overturned, okay? And so that's the way that it has to go. And then, of course, if it's overturned, then you get back into court, and then, if they qualify, you can apply for adjustment or whatever else it happens to be. So in a following immigration video, what I'm going to be talking more is about the adverse credibility finding and how to avoid that and what some of the cases are on that and so forth. But because the filing of a frivolous application is so much more severe, that's why I have concentrated on this particular video. So you have to ask yourself, why is it so severe? Why do they make this ruling? Well, the bottom line is they don't want people trying to come to the U.S. and file fake asylum applications to get benefits. So, of course, one way to dissuade them from doing that is to say, if we rule that you have done that, you're never, for the rest of your life, going to be eligible for anything in immigration law. And so when preparing the application, you have to go to someone who knows what they're doing, who's familiar with asylum law, who knows how to make good cases. Now, keep in mind, there is one thing making a good asylum case and losing versus getting a ruling of a frivolous asylum application. They're two different things. You can definitely have a valid asylum application and lose, okay? As a matter of fact, the last statistic I looked at was basically the percentage of asylum cases that win is just below 17%, which means 83% more or less lose. Okay, and it doesn't mean you can't appeal it and appeal it again, do a petition for review, motion to reopen, all kinds of relief that might ultimately be available to you. But the bottom line is that losing an asylum case versus getting the ruling of a fraudulently filed asylum case are two completely different things. So make sure you get someone who knows what they're doing. Okay. So if you like this video, click like. Also, go ahead and subscribe. I do usually videos once a week, give or take, some in English, some in Spanish. And then you can go ahead and give my office a call or go online and book an appointment online. It's all automated, and then I give you a initial free consultation. Okay, that should do it for this one. More on the coming videos.